There are 4 types of statuses that you can declare. Each of them has a different function. They can either allow or not allow you to do certain things, and they can assign you the type of duty rate that you'll get once you export something from the FTZ. And this is the reason why it's very essential for you, for an importer, to consult a customs broker before they transfer something into the FTZ. So that way the broker can help the importer determine what type of status is actually the correct status and the most beneficial to the importer. Because if an importer takes something into FTZ and it ends up being the wrong status, they might not be able to do something that they want to, or they may end up paying a lot more than they initially planned to. So the first one is privilege status. When you declare something as a privilege status, this means the duty was frozen when the parts entered the FTZ. This is also sometimes referred to as parts. So what does this mean? What this means is that, for example, if you have goods which have 1% duty rate when it entered the US, those goods, you take them inside the free trade zone for whatever reason, and it's declared a privileged status. So let's say that you want to bring something into an FTZ. You're shipping something from UK to the US and inside an FTZ without making an entry. You can bring something from the UK and take it into the FTZ, and whatever the duty rate was at that time when you made an FTZ entry, no matter what happens to the duty rate, whenever you export those items from the FTZ and make an entry inside the US, those items will have that initial duty rate. For example, when you make an FTZ entry, let's say the duty rate is 1%. But by the time you take those items out from an FTZ, the duty rate jumped to 25%. When you take those items out from the FTZ and make an entry inside the US, you will still have to pay only 1% duty rate rather than the 25%. And also, when you declare something as a privileged status, if you do an assembly within the free trade zone, that assembly cost is not dutiable. So let's say you bring in a bunch of parts from UK into the US and then into an FTZ, and then you assemble all those parts. Generally, if you assemble those parts inside the UK, you would have to add that assembly process cost to the entered value goods and then pay duty on that entered value. But in this case, if you assemble something within the FTZ and then export it, that initial duty cost is going to only be on the parts price themselves. And it's only going to be the initial duty rate, even if the duty rate changed since then. The second type of status is non-privileged. In this case, the duty frozen as item leaves. This is also known as parts as cars. So let's say, for example, you bring in a bunch of parts for a truck from different places. You bring in those parts inside the US and into an FTZ and declare the status as non-privileged. And then you assemble those items together and you form a truck. When you take that truck out from an FTZ, the duty will be on the final end item that you made rather than the initial duty rate for each part. So in the privileged status, if you brought in truck parts, assembled them together, took them out as a truck, the duty rate would be the initial duty rate for when you brought those parts in. But for non-privileged status, the duty rate is going to be whatever the end item duty rate is when you leave the FTZ. In this case, the duty rate of the truck. The third type of status is called domestic. When you declare domestic status, it's usually for foreign-made items which you already paid duty for, or items which have a country of origin as US. That way, for example, if you bring in something from UK and made an entry inside the US, you already paid duty for it. So when you take it inside an FTZ and you do something to it, or if you assemble it within something else and make another end item, you can actually take away the amount of that domestic status part. So that way, when you're paying duty on the whole item, you end up not paying duty twice on the same item. Or if something is US origin, you end up not paying for duty for the item which has a country of origin as US. The last type of status is zone restricted. For this type of status, you cannot enter the goods into US economy. You cannot do a consumption entry. This type of status is needed for the following reasons. 1, if you plan to export something from the US. 2, if you plan to destroy something within the FTZ. 3, if you plan to ship something to an FTZ for TIB cancellation. Remember, TIB is something when you bring in something temporarily inside the US and you can only have that item within the US for 1 year. Once that year is over, you have to export that item from the US. So in this case, when you have a TIB item and you plan to cancel that TIB bond, you can take something into the FTZ if you declare it as zone restricted item. That way the cancellation happens, and then from there on you can export that from the US. The fourth item is if you plan to do drawback. You need to make sure that your items have a zone restricted status. What if you want to transfer your goods from an FTZ? Let's say you want to transfer the items from FTZ to another FTZ. Can you just do that, and how do you do that? Yes, if you want to transfer goods from one FTZ to another one, you can go ahead and do that. That's no problem. It just depends what type of form you have to fill out. So for example, if you're transferring FTZ to an FTZ and both foreign trade zones are within the same port and the same operator, then you'll need to fill out the 6043, which is a delivery ticket. If you're transporting something within the same port but has a different operator, then you need to do things a bit differently. You have to fill out customs form 7512, I believe, which is a transportation entry, and you need to fill out customs form 214. If you're transferring between two FTZs which are at different port, then you only need to fill out 7512, which is a transportation entry, and customs form 214 as well. What if you want to export something from the FTZ? In this case, you just need to fill out customs form 7512. What if you want to do a consumption entry from an FTZ? In that case, you do an entry, which is customs form 3461, and customs form 7501, which is an entry summary. Or you can always do 7501, which is entry or entry summary together, which is again known as presentation. I mean, that was it about the foreign trade zones. As you can see, they have some similarity to warehouses. Warehouses and foreign trade zones kind of function the same way, but they have different functions. So that was it about FTZs. And now we're going to move on to topic number 3, which is examination, or examination site, I guess. We'll label this as examination. Again, if you haven't subscribed on YouTube, go click on my YouTube link and click on the subscribe button, especially if you've learned anything from any of these lectures. So what is examination and where does it actually happen? If something is entering the US and customs has a reason to check out those items, they will check out those items at one of the examination sites. In other words, they will examine the stuff at the examination sites. So where are the examination sites? Where does the examination happen? Examination usually happens at the place of arrival, except when it's required to be examined at a public store. It can also happen at something called a central examination site, or it can happen at the importer's premise for whatever reasons. Maybe the importer brought something in unassembled and then it needs to be assembled before the customs, before CBP can have a look at it or examine it. So that way the importer will have to bring the items inside an importer's premise, assemble it, and let CBP come in and check out the item at the importer's premise. When does it happen? Examination usually takes place after the items have made an entry inside the US or entry into a warehouse. Of course, it can happen before as well, but then there's different rules and regulations for that. For example, if an importer wants examination to happen before an entry is made, they have to actually reimburse CBP for the work they do before an entry is made. How many items are examined when something comes in? Usually CBP requires at least one package out of every 10 to be examined for an importation entry. So for example, if an importer has 10 packages coming in, CBP requires them to check at least one package. If they have 20 packages come in, then in that case, CBP is required to check 2 packages. You have to understand that examination doesn't have to happen when something enters the US. It can also happen at foreign ports. And honestly, that's all I had for examination sites. It's not a big topic, but it does come in here and there. One question maybe every couple of exams, I'd say. Next, we're going to talk about topic number 4, which is trade names, trademarks, and copyrights. And I guess I can just add patents. I mean, you can copyright patents, trade names, trademarks, or patents, but I don't know, customs can be a bit difficult. So let's go through some definitions. What are trade names? A trade name is an official name under which an individual or a company conducts business. A trademark, on the other hand, is usually a mark or a logo that's associated with a trade name. Sometimes it can be difficult to distinguish between a trade name and a trademark, so honestly, they never really ask you for an exact definition. I wouldn't really worry too much about it. The third one is, I guess, patent, which is a registered mechanical process that shows how something works. And I guess the fourth one would be a copyright, which I don't really quite honestly know how to explain, because you can have a copyright and a patent, trade name, or trademark, but it can also be other things, I guess. A copyright is just pretty much an exclusive right to use something, and it's usually a logo. So let's talk about trade names. If you want to register a trade name, you have to pay $190 fee per class of goods. For example, if you're registering 5 different classes of goods, and then you have to pay $190 for each single class. But if you're registering 5 different products, which are of the same class, then you only have to pay $190 for each class, which is all 5 products in this case. And you need to pay $80 to renew per class. A trade name lasts for 20 years. And when you have to renew this, you have to renew a trade name no more than 3 months after its expiration. Next, let's discuss copyright. Copyright, same thing, $190 per class initially, and then is assigned to those goods or that manufacturer. That's pretty much I had for ADD and CVD. There's not much on it before 19 CFR Part 200. And I know that on the older exam there were a couple of other things or a couple of the details which kind of occurred after Part 200, but it seems like the future exams, or at least the present exam, do not have anything that comes from anything that's beyond the Part 200. So I don't think there's much you have to worry about. Whatever you want to learn about ADD and CVD, you can learn about it by doing the previous questions or previous exams up until today, which is 2020. The next topic is exportation. In regards to exportation, there's not much. Every time something is exported, there are certain rules and regulations that need to be met by the carrier mostly, which will take the stuff out. But I guess the one thing that you really need to know is what's known as SED, which is Shipper's Export Declaration. It's also sometimes known as the SLI, Shipper's Letter of Instruction. So when you as a company or as an exporter are sending something outside from the US, export something from the US, if your HTS or technically Schedule B, if your Schedule B is valued above 2,500, you're supposed to fill out this form called the SED or SLI. This form lists everything by Schedule B. So for example, if you have 5 items, they all have the same Schedule B, then you only need to list one line for the shipment. And if those 5 items have different Schedule Bs, then you need to really only list the items which have a Schedule B value of more than 2,500. This serves kind of like an export declaration for anything over Schedule B of 2,500. And I guess the other thing you need to know that SED or SLI has besides Schedule B is the ECCN number. ECCN number is pretty much an export declaration, and it, if done correctly, it'll tell you exactly which products require a license before you can export them from the US. So there's a whole exportation guideline which you can look at if you go online, and it'll guide you exactly how you can assign Schedule B and ECCN numbers. And depending on the ECCN number, it'll show you what kind of license would be required, if any, for anything exporting from the US. The next subject that I'm going to quickly talk about is quotas. Quotas are pretty much ways to limit a foreign item coming into the US. There are 2 types of quotas: a tariff rate quota and an absolute quota. A tariff rate quota is a quota or a limited amount of quantity of something that you can bring in at a reduced duty rate. And once that number is met, the duty rate goes up very high. So for example, let's say that the US has a quota on diamond frames, in the sense that the 25 first diamond frames that enter the US, they can enter the US at a duty rate of 0%. And then everything beyond the first 25 will have 1,000% duty rate. So that way, the first 25 diamond frames, they'll have 0% duty rate. And then after that, it's going to discourage importers to bring in those diamond frames because it's probably going to cost them more than what they're going to make. On the other hand, absolute quota is when there's a limited quantity that can enter the US, period. So let's say there's a diamond frame absolute quota of 25. That means only the first 25 frames to enter the US can enter the US. If someone tries to enter diamond frames inside the US beyond that 25 quantity, they won't be able to. So when do these quotas open up for importers to actually know that they're open and they can be a part of this quota race? Do they open at any time whenever CBP feels like it or what? There is actually a specific time for these quotas to open up, and they always open up at 12 p.m. Eastern time. If for some reason when the quotas open up and they close suddenly because pretty much everyone entered the quota, what will happen is that CBP will assign a prorated number or quantity to each importer. So for example, if let's say the quota opens at 12 p.m. and right at that time everyone put in their papers to be part of that quota. Let's say there's an absolute quota of 100 and there are two importers who try to import 100 each. Rather than having one importer enter 100 and nothing for the second one, if they both enter the quota at the same time, CBP will actually split the quota between those two importers, send the paperwork back to them, and ask them to resubmit the entry summaries with the amount that they adjusted. Quota, as you can probably guess, depends on the country of origin. Not on the country of export, not on anything else, country of origin. It's essentially, for example, if the country of origin is China, we're going to limit stuff from China. It's usually against countries and it's usually done for trade facilitation. That's it about quotas. Now let's move on to the next topic. Let's say you did your entry, it's all done, it entered the US, your goods are good to go. What happens then? When does customs stop having interest in your stuff? Once you make an entry, does that mean customs at any time in the future, even 50 years from now on, can they just come back and ask to re-examine the stuff? Can they come back and be like, oh, you did something wrong, so we're going to fine you? Like, well, how does it work? What happens after something enters and it's all done good? So because of that, we're going to be talking about liquidation, protests, and post-summary questions. So what is liquidation? Liquidation happens when CBP loses all interest in your imported article. This usually takes 1 year. When your stuff is liquidated, that means CBP no longer is interested in it. They no longer care about it. And when the liquidation date occurs, it will actually be posted online. And so you can check to confirm that it's been liquidated. Or 1 year from withdrawal from a warehouse if you made a warehouse entry. So for example, if you make a warehouse entry and then you keep the stuff for 4 years inside the warehouse, that doesn't mean that from 1 year of warehouse entry, CBP is no longer going to care. They are going to still care because it was a warehouse entry. But once you withdraw something from the warehouse, 1 year from the date of withdrawal from the warehouse is when the liquidation is going to happen for the item. And you can also extend liquidation 3 times. For whatever reason, maybe CBP extends your liquidation because they're looking deeper into it. Maybe you want to extend the liquidation of your goods because of something. You can only do it 3 times. So that means the total amount of liquidation cannot ever exceed 4 years. So what is a protest? A protest is pretty much fighting a decision that's been made from CBP. You can pretty much protest everything except fines. So for example, you can protest clerical errors, mistakes of facts, other inadvertencies, administrative decision, etc. What you cannot protest are fines given to you by CBP. So when can you make a protest? If your entry was made before December 18, 2014, the protest needed to be within 90 days. But if your entry is made after December 18, 2014, then the protest can be made within 180 days. So for the exam, you have to actually see when the entry was made. They can be a bit tricky on this. Sometimes they'll put a couple of days before December 18th. Sometimes they'll change the year up and try to confuse you. But when they give a question about timing of a protest, just be careful which date they're talking about. And there are two types of kind of protests that you can, depending on how fast you want a decision from CBP. One is the regular kind, for which the decision can take up to 2 years. And then there's the accelerated type, where the decision has to be made within 30 days. And then if for some reason they don't reply to you within 30 days, that just means that you lost. And actually there's a third kind too, I guess. You can also do something called application for further review. It's on Customs 419, and that you go to the headquarters if your protest has been denied by the port director. And then we have a third one, which is called PSC, also known as a post summary correction. And as you can see, you can do a PSC when there was a error on your 7501 but you want to correct it, but you can only do it if there's a difference in value of your 7501 more than $20. And this was essentially liquidation, protest, and post summary corrections. Now let's move on to the 9th topic. I know guys, we're jumping through these topics like crazy, and I'm just giving you pretty much the overall understanding or highlight of what each topic is. But as I've said previously in the past, remember these lectures, they're supposed to give you an overview of where things fall and how those things work. Where you need to learn the details is by doing previous practice exams. That's where all the details is. Once you have an overall understanding and where things fall, if you read a question on the exam, you will know exactly which topic it falls under and where to look at for those topics. So the 9th topic we're going to be talking about is penalties. Again, it's going to be a high level overview of penalties, and it's not going to discuss every single thing that you might need to know. So for this, let's talk about customs broker penalties that are probably in part 111, which I didn't mention before, but I'm going to kind of go through and see the different kinds of penalties that can happen, or why a customs broker might get a penalty and how much the maximum is. A customs broker penalty cannot exceed an aggregate of $30,000 for any of the following penalties. The first one is statement that was false, misleading, or omitted to report material fact which were required. The second is broker convicted after filing a license application of any felony or misdemeanor which involves the importation or exportation of merchandise and arose out of conduct of customs business. Third, violation of any provision of any law enforced by customs. Number 4, broker has counseled, commanded, induced, procured, or knowingly aided or abetted the violation of law enforced by customs. Number 5, broker has knowingly employed or continues to employ any person who has been convicted of a felony without written approval of the employment from the assistant commissioner. Number 6, broker in relation to customs broker business with intent to defraud, deceive, mislead, or threaten any client or prospective client. And number 7, broker no longer meets the applicable requirements. So what are the different types of violations that can occur? There are penalties for violations occurring of 19 USC 1497, 1592, 1641, and 1593. For this, you need to check out part 171. There's a lot of detail, and I think the best thing to do would be to highlight each section of each type of section violation. For example, in section 1497, let's say there are different types of violations that can happen. I would highlight the main title under one color and then highlight the different types of violations that can occur under that heading and what the penalties would be. These questions can be very random. They can honestly ask you any type of question regarding the violation. So I would just kind of go through and highlight each at least a section heading. That way you know exactly what to look for through all those pages when you're looking at the question on the exam. So for 1497, these are violations that can happen for passengers. For 1592, these are violations that can happen with importers or brokers. 1593, violations can happen with drawback. And then 1641 violations can happen with, again, brokers. I'll go ahead and briefly discuss two types of sections and the kind of violations and penalties you can get for them. I'm going to be discussing section 592, Tariff Act of 1930, and section 593. So when they talk about 19 USC, and for example you see 1497, That's actually referring to section 497. The USC 1592 serves as a carnet serves as an entry and as a bond. There are three types of carnets. The first one is known as ATA, which is kind of a temporary admission between US and another carnet company. It is valid for 1 year once you get it, and you cannot do a consumption entry in any of the countries you go to. The second type of carnet is known as TIR, or tier. This is also known as Transport International Routier. This is usually for truckers and usually in Europe. This has no time limit and you are allowed to make an entry in the last country that you visit. So for example, if